Okay, welcome to Copyright Law for Artists. Today we're joined by Erin Rodgers, a partner with Rodgers Silvera, a full-service entertainment law firm concentrating in business counseling, intellectual property, contracts, civil litigation licensing, and financing. Ms. Rodgers has been practicing entertainment and nonprofit law in the Houston area since 2007. She holds a bachelor's in music business from Loyola University, New Orleans, and a JD from the University of Houston Law Center. She's spoken at many entertainment industry events and teaches copyright and business courses at the Art Institute of Houston. She has served on the Texas Entertainment and Sports Law Council and is a member of the National Academy of Recording Arts and Sciences. In addition to practicing law, Ms. Rodgers is a classically trained clarinetist and also plays the piano, accordion, and guitar. She has performed as a vocalist with Dave Brubeck and the Louisiana Philharmonic Orchestra, and currently performs with Houston indie rock bands, the Wheel Workers and Glass the Sky, as well as several other groups around town. I will now hand it over to Ms. Rodgers. Thank you for leading this discussion today.
Yeah, sure, happy to be here. I've spoken at the Printing Museum, but it was a million years ago, so I don't know if any of you were there back then. But if you were, this is new information because there's quite a few things that have changed about copyright just in the last couple of years. And in fact, in the last year, and some big changes that are coming up, hopefully in December, which we'll get through. So I have a PowerPoint I'm going to share. Give me just a second. Okay, all good? We're cool? Okay, great. Let's just get started. So I'm going to split this into a couple different sections, and feel free, as Brian said, to put questions in the chat and then we'll go through them. I'm happy to answer questions because even though copyright law is sort of the same across the board for every media, or it's supposed to be, when it gets down to it in practice, that's actually not always true. So if you have a specific question about an area that, a media that you work in, and you'd like me to answer something about that specifically, let me know. So anyway, a copyright is actually 6 different rights. So first of all, it's important to understand what you have with your own copyright, and then we'll get into using other people's copyrights and sharing and permissions and things like that. But before we can get at any of that, you have to sort of know what a copyright is. And first of all, you guys already have a copyright. If you've ever taken a picture on your phone, if you've ever written something on a piece of paper, or recorded a song into your recorded device, you already have a copyright in that. You don't have to do anything to have that. So you're all copyright owners. Congratulations, this applies to you. So what does that mean for you? You have 6 different rights that come along with having a copyright, which is the right to reproduce, the right to make copies, that's the obvious one. The right to make derivative works, which we're going to come back to because that's a really important one. And that is essentially using other people's works to make something new, whether that's a collage out of existing artwork or making a movie out of a book. But that's a big one and one of the most contentious ones that has the most complicated factors with it. So I've got separate slides and we're going to come back to that. The right to distribute copies. And then the next 2 are related depending on your media. The right to public display or the right to public performance, whether we're talking about art or music or a film. And then the last one is sort of the weird one that got tacked on way later because we started doing things like streaming and audio transmission. So, and it didn't really fit under anything else. So the right to perform via digital audio transmission, but really we're mostly talking about those first 5. And the reason this is relevant is that if you want to get rights from someone, you don't necessarily need the rights to all 6 of these things. You might just need 1 or 2, and vice versa. If someone is trying to get rights from you for something, you might not need to give them all of them. Just for example, as a musician, if I wanted to have vinyl records made, I would want to give the record pressing plant the right to reproduce my record, but not the right to distribute it. They're not going to sell it. They just are going to make it for me. So that's why it's important to know the difference between all these things. And also these are the things that you can't do without someone else's permission for their works, and except for fair use, which we will also come back to. What can you copyright? The standard for what you can copyright is actually pretty low. So as opposed to, say, a trademark, which is your business name or your logo, For those, no one else can be using a similar business name or logo currently. And then there's patents where no one can ever have had a patent on that thing. With copyright, it just has to be an original work of authorship. And original just means original to you. It doesn't mean creative. It doesn't mean best artwork of all time. It just means you did it yourself. So the good thing about that is it's easy to get a copyright. The bad thing about that is, depending on the nature of your work, if I happen to paint a painting of a cat at my house and you've never seen it, I've never shown it to anyone, it's just in my bedroom, and someone in Wisconsin paints a really similar painting of a cat, we could both have a copyright on our very similar paintings, and we're just sort of stuck in trying to make each other quit. So that's the downside of how easy it is to get a copyright, but it's pretty simple. So some creativity at all, you're probably going to be able to register it. You can't protect an idea though, just your expression of the idea. And that's why often once one TV show becomes popular, there'll be 400 knockoffs of that sort of TV show. That's why there can be 8,000 dating shows and 8,000 cooking shows, because you can't have a copyright on the concept of having a cooking show, just on your cooking show, your dialogue, your video. So you're just copywriting your expression of that idea. And authorship doesn't just mean author in the sense of a book, it means the creator of the work. So it's broader than it might sound like in that definition. Who owns a copyright? This is a complicated section. So the obvious one is the creator themselves. If I record a song into my phone and I wrote it by myself and no one else is singing with me and no one else did anything, I own it outright by myself. If I have a collaborator, maybe I wrote the music and someone else wrote the lyrics, then that's a joint work and we own it together. And I'm going to come back to that. You can also transfer a copyright via contract. And this, again, is one of those things where it really depends on the media, because, for example, in music, if I hire a saxophone player to come into the studio and play on my album, it's sort of understood that I'm going to own that. But on the other hand, if you're a photographer or a graphic designer, the default is that you keep the copyright, not the person you did the work for. And if they want the copyright, that would be unusual and they'd have to ask you for it. So that's one of those things that varies. And I'm sort of overlapping with work for hire. Work for hire is a really important term to understand. I teach copyright classes at Art Institute and also at HCC. And this is something that is on every test that I give and every project, because it's super important to understand. And that is that a work for hire means that you never owned the work that you did. If you did work for someone else as a work for hire, it's not yours, it's theirs. And that's not necessarily bad, depending on the situation. So again, if you're a graphic designer and you're making a logo for someone, maybe you don't care that you're not keeping the copyright in that, because what were you ever going to do with someone else's logo? But it's still important to know that that's what you're giving up if you sign a contract that says this is a work for hire. And I think I have another slide on that, so we'll talk more about it in a second. Okay, I said I was going to come back to joint works. You're working with someone else. So you're writing a book together. You've written most of the book, and then you have a friend come in and write another chapter. That's a joint work unless you have a contract that says it isn't, because anytime you have separate people contributing something copyrightable to an entire work and you meant for that to happen, it's a joint work. And there's reasons why that's important. Copyrightable contribution means, for example, if I wrote a whole book and then I gave it to you to proofread and you read it and you said, I really think you should change April to May. And I say, okay, that's not a copyrightable contribution, that's one word. But if you said, I got really inspired and I wrote a whole chapter, that's a copyrightable contribution, because you could copyright that chapter by itself. So now we're joint owners. And we also don't have to have worked together necessarily. So this happens a lot in music, where maybe I've written a piano piece and I think someday I'm going to get somebody to write some vocals for this. I don't know who it's going to be and I don't know when, but I'm going to do that. And then 2 years later, I meet you and you write vocals for my piano piece and we combine them. Now it's a joint work. Why does that matter? Because if you don't have an agreement in writing about who owns what, the default is that it's equal. So even in my example of I wrote the whole book and then you came along and wrote a chapter's worth of words. So maybe I wrote 90% and you wrote 10%. If we don't have something in writing to the contrary, it's 50-50. It also matters because either of us can give permission to anyone to use it. So maybe we wrote a song together and a company you really hate wants to use it in their commercial. I can say yes, and I don't have to ask you. I have to pay you. I have to pay you your share of whatever your percentage was, but I don't have to ask you. So you can have a written agreement that gets around all of that. So the point of this is, if you're working with someone else, always sit down when you're done and talk about it right then, before there's money, before you forget what happened, and decide how you want to split it. Because you can decide anything you want. You can say it's 75-25, it's 50-50, it's 90-10, it doesn't matter. You can also say, we're not going to license anything to anyone without talking to each other. But if you don't do that, these are the default rules, and you might not like where that takes you. I find that people are friends until there's money, and then suddenly everyone did most of the work when we're trying to figure out who owns what. And works for hire, I said I'd come back to that too. There's two ways a work for hire can come up. It can be your job. You are employed by Disney. You are an animator. That is your job to animate for Disney. That's a work for hire, and you don't own anything. They're going to pay you, and they're going to give you credit maybe, but it's not yours, it's theirs. But the other way it can come up is in a contract. So a commission is not automatically a work for hire. And this is something I see a lot in my work, including today, actually. I had a musician tell me, but I paid the bass player, so I own that, right? I'm like, nope. There has to be a written document that says it is a work for hire before the work is done. So that's just something to understand. If you are putting together a movie is the best example of this, because there's always about 100 people working on any given film. You don't want 100 owners. So it makes sense that everything is a work for hire for one entity that's going to own the whole thing. But you need to know that that's what's happening. And everyone needs to sign off on it and say, I'm the editor, it's a work for hire. I designed the costumes, it's a work for hire. So just know that if you see those words in a contract, that's what it means, that you're giving up your copyright. Yeah, but it has to be in writing, and just paying someone does not make it a work for hire. You have to say so. So money is not enough to affect the ownership. Other way around too. It can be a work for hire without cash, as long as there's some sort of trade, but it could just be credit. So money doesn't change ownership ever. When is a work copyrighted? So I already said you all already own a copyright. All you have to do is fix it in a tangible medium, which means record it, write it, take a picture, whatever it is, in a way that you could show it to somebody. It's not just contemporaneous speaking. You didn't just say, I think I'm going to paint this tomorrow. But if you have done so and you have a physical product you can share with someone, then you already have a copyright. You can write the date on it. If you write the little C in a circle with the year, that's really helpful later if you ever have any issues with proving that somebody knew they were infringing your copyright. That can be helpful. I know that sometimes in visual art, artists don't want to physically put the date on the work, because sometimes that's a problem when they go to a gallery and the work was actually done in 2017 and now it's not new and cool anymore. So in that case, you can take a photo of it and your phone will save the metadata as far as when you took that photo. Some of you might have heard of the poor man's copyright, which is mailing it to yourself. Don't bother. The thinking behind that is that if you mail something to yourself and you don't open it, then it's postmarked. And then you'll be able to prove that you did this work before the date of the postmark. But the problem is either you registered your copyright or you didn't. So if you registered your copyright, you get certain benefits. If you didn't register your copyright, it doesn't matter whether or not you mail it to yourself. You already have a copyright. It doesn't help you. So just mail it to the Copyright Office instead, which I'll tell you how to do in a minute. So why should you register if you already have a copyright? What is the point? I don't think you need to register everything you ever did, but if this is something that you're going to market or do something with, or this is your best work ever, then you should register it before somebody starts infringing it. Or if you know you're going to start pushing this particular work or marketing it or trying to display it, then I would register that one before you go do that. And there are a few reasons, some of them nice and some of them not so nice. First of all, the most important reason and the least nice reason is that if you have not registered your copyright and you want to sue somebody for copyright infringement, it's really difficult to prove the damages. If you have registered your copyright, there are statutory damages that are set by law that you can go after, regardless of what you can prove that you lost. And even if I don't like litigation, I try to avoid it. But it does go a long way towards negotiating. If you can say, I could sue you for $30,000, but what I really want is credit for you to take it down, to collaborate with me next time, whatever it is that you actually want, or less money. But it makes that conversation go faster if you can start with that. So not that I'm complaining if you do feel like that's what you want to do, sure, but you don't have to. There's still value in it. Also, the Copyright Office has a database. Historically, it has been pretty crappy, but they are going through a lot of renovations over there and it's getting better. But I have definitely used it to find people to pay them, because I've had clients come to me and say, I found this photo, I love it, I want to use it as the cover of my book. How do I find the owner of this photo? And you can use the Copyright Office records often to find that person and contact them and say, we want to pay you to use your photo on this book. So that can be helpful. And then also, it's just not that hard. You only have to register your copyright once. You never have to renew it. It's not that expensive compared to the other things. Like a patent is thousands of dollars. Trademark filing fees alone, without paying someone to do them for you, start at $250. And copyright, you can do yourself. You don't need a lawyer to do copyright for you. I mean, I do them for people who don't want to do them for themselves, and I'm totally happy to do that. But you don't need someone else to do it for you. You can set up an account and do it yourself. So there's really not a reason not to. It's just not that complicated, and it's not that expensive in the grand scheme of legal things. So if you wanted to register, you register through copyright.gov. And these prices here are relatively recent. So if you've registered a copyright before 2020, probably, these prices were different. So, and the forms were different. They have made a couple changes I don't like. So this is important. The standard form now is only for works that were registered, that were published together, or for single works that have more than one owner or are owned by a company or something like that. If you are the sole owner of a single work, you can register that one for $45 separately. But if, say, you have an LLC that controls all of your artwork, then you couldn't use that form. You'd have to use the standard form. And when I say published together, I mean, for example, if you had a book of photographs that you published as a book, and there are 100 photographs in that book, you could put those 100 photographs together. They all have to be the same category, though. If you publish a book of photographs and poetry, you'd have to put the poetry on the literary application and the photos on the visual application. So they have to match. And then this is the new thing that I don't like. So it used to be that you could put as many unpublished works together as you wanted on a single form, as long as the details were the same. So if you had 8,000 poems, you'd have to sit there and write all the titles out. But theoretically, you could have put all 8,000 of those poems on the same copyright registration. You cannot do that anymore. You can register 10 at a time. There's a different cap for photos. I don't want to tell you that I remember what it is. It's much higher than 10. But photos is the only exception. Everything else, 10 songs, 10 poems, whatever it is at a time, and that is $85. So what I often advise people to do, if they are prolific enough that they're going to create at least 10 works in a year and they're not going to do anything with them right away, is to go ahead and get several together and then go ahead and register them. You don't have to re-register once you've published. So you could put 10 art pieces together on the same form and then put them out after that. So that is new. Like I said, if you've registered in the past few years, this might be different than what you saw before. They are also updating some other forms. There's going to be a form particularly for music, because that gets really complicated these days, because so many things have different featured artists and producers and different songwriters on every song. And the way it is now, you have to register every song separately, even if they're all on the same album, because they all have different people on them. So I'm hoping that the new form for that will fix that problem and make it easier to handle that. I already talked about this, but we should talk a little bit about what published means. So published, the definition of published works is available for sale, lease, or lending. The last time that I did a deep dive into trying to answer this question, there was no answer to this question. If it has been answered since then, I'm unaware. But that question is, if I post something on Facebook and it is not downloadable, but it's just there on my Facebook page, is that published? And there, as I know, has not been a good answer to that. If somebody can download it, then you could say it's for sale, lease, or lending. But if you're just streaming a song that somebody can listen to for free on your own website, is that published? My inclination is yes. I would err on the side of caution with that and say, if I'm going to publicly post this somewhere, that looks like publication to me, but it's not technically sale, lease, or lending if you're just looking at it for free. So yeah, that's a unresolved question. But like I said, I would treat it as, yes, that is published. Okay, so copyrights last a really long time. Copyrights last for your life plus 70 years after you die. If you're talking about a joint work that there's more than one person, so it's the life of the person who lives longest plus 70 years. Works for hire are 95 years. The reason that it's different is because companies don't necessarily die, and the copyright is a balance on the First Amendment right to free speech. So free speech, we can say whatever we want, except if it's my speech, you can't necessarily use it if it's keeping me from making money, because I would be disincentivized from making more works. But also at some point, there's a time at which it's more valuable for the public to have access to those works. It wouldn't be fair if the Mona Lisa was still under copyright. That would be dumb. So 95 years is the current work for hire length, and you can blame Disney for it being that long.
But I have a quick question about that.
Yes.
So, but don't like museums own reproduction rights? Aren't there reproduction right agencies for like famous pieces of art so that people don't use them like indiscriminately?
Yes and no. So that doesn't take the work out of the public domain, but often the museum is the one that has the original, and they can control, just by the fact of having the original work, can somewhat control how that is used. Just for example, I have a client that was making a documentary film and wanted some footage from like a 40s TV show that actually is public domain because it wasn't properly registered, blah, blah, blah. But UCLA's film school has the physical footage, and there's no other way to get it other than to pay them a reproduction fee to make it for you. Even though technically, if we had been able to find that footage somewhere else, probably that'd be fine. It's public domain, but they're the ones who control it, and they watermark it, and you pay them to clean it up and send you what you wanted. So yes and no. But that doesn't give them the right to extend the copyright in the underlying work. But if they control the physical work and can do that, then sure, that does happen. Good question. So under these rules came out of the 1976 Copyright Act. So things that are older than that are not always under the same rules, because prior to that, there were policies that required you to renew your copyright. So it's possible that even though right now the public domain is 1925 and older, there could be things that are newer than that are in the public domain because somebody did not renew it properly back in the 30s or something, which is sort of what happened with this TV show thing and why it's technically public domain. And we do gain a year of public domain works every year. So this year, 1925 went into the public domain. That includes The Great Gatsby and a bunch of other stuff. But on January 1st, we'll also get all the works from 1926. So in the visual art world, that actually means something to you guys. Most of my students are musicians. So I'm like, you can use songs that are older than 1925. Go for it. It's just not a lot, unless you want to make a Mozart arrangement or something. But at least in visual art, there's more useful things that are older than that. Okay, and I said I was going to come back to derivative work. So I want to talk about this one. This is a big one. And I know this is something that you guys were interested in, as I was told prior to this conversation. So again, a derivative is one of the 6 rights that you get with your copyright. And it is anytime you're taking one or more existing works and making it into something new. So from an artistic perspective, again, that could be a collage. It could be a painting of a photo. It could be a translation of a book into another language, anything like that, where you're taking something that exists and making something new from it. And that is something that technically you are supposed to have rights for. So we're going to talk about fair use in a minute, but there are a lot of misconceptions about fair use and about derivatives and what's okay and what is not. There is no magical number that makes a derivative not infringement. For example, in my music stuff, I always hear people say, but I took less than 10 seconds, doesn't matter. Or in film, it's 30 seconds, right? Like, no, that is not a thing. It's never been a thing. There is no number. There's no percentage. That's all not a thing. I don't know where that myth comes from. You can use portions of things and make it could be fair use if you're using less, but there's no explicit statutory amount of anything that makes it fair use as opposed to copyright infringement as a derivative. But if you're making something that is derivative, your copyright, if you have permission to do it, extends to the new thing that you made. So I think the easiest way to think about this is a translation. So say there's a book, I want to translate that book into French, so I get the rights from the publisher to do so. That doesn't give me any rights in the original English version of the book. I can't stop somebody else from doing something with that book, but I could have a copyright in my French version and no one can infringe my translation and my version of that. But somebody else could translate it into Russian and somebody else could translate it into French for that matter, as long as they're not using my version and I don't have a contract that says you're not going to let anyone else do that. So that would be a contract question, though, not a copyright question.
Erin, you had to get permission from the original English writer to do the translation into French, correct? And possibly pay them for the right to do that first?
Correct.
Okay.
Yes. And as far as how that process works, as far as paying them and what that looks like, that's going to vary dramatically, because it could be a situation where you say, I'm going to pay you a flat fee, you're going to let me do this, I can have all the money from whatever I do with it, we're done. Or it could be, I'm going to pay you nothing up front, but I'm going to pay you 30% of my book sales when I actually go sell this book, or something like that. There's so many different ways to work it out, but you do need that permission to do that. But something that I want to differentiate here is, I've got it here on my last part of the slide, the Lee lawsuit, is the derivative works versus what's called the first sale doctrine, which says that you can do whatever you want with your copy of something. So if I want to go get a painting from Goodwill and I want to paint aliens into this landscape, I can do that. I can't make copies of it and I can't, distribute those copies. But if I just want to do that and hang it up on my wall, I absolutely can. I can do whatever I want. I can run that painting over with my car. I can sell it to someone else. I can paint over it and use the canvas again. Because I own that copy of the work and can do whatever I want with it, as long as I'm not doing one of those other 6 things we talked about in the first place. So what this case was about was, and we've all seen things like this, it's a popular thing to do. A store owner was cutting up cards, I believe they were Hallmark cards, and gluing images from Hallmark cards onto coasters and selling them, like decoupaging them and selling them. She wasn't doing anything to them. She wasn't making a collage or a drawing on it or anything. She was literally cutting a square out of a greeting card, gluing it to a coaster and selling it. And the greeting card company sued her and they lost because of the first sale doctrine, because she was not making copies of the greeting cards. She was purchasing them and she could do whatever she wanted with that card that she purchased. So that was legal because that's first sale, not a derivative work. Any other questions on that stuff before I get into licensing?
There's a question in the chat that says, and Chris, you might want to unmute yourself and clarify if I'm not reading this right. Does that apply to your own translation of a public domain work? And I'm not sure what that.
Yes, I totally get your question.
Okay.
So yes, like if you wanted to translate the Count of Monte Cristo or something like that. So 2 things that complicate that though. Yes, you could do that, but you can't be translating someone else's version that still has a copyright on it. So if you're using some newer version that someone else does still have a copyright on, you have to be careful about that. And then you would have a copyright in your translation, but it would not extend the right in that original version. Or I think another example that makes that clear is if you're thinking about recording a Mozart piece and you want to make a new arrangement of Mozart for a synthesizer, you can do that because Mozart's in the public domain, but you also can't stop someone else from doing the same thing. You can just protect your arrangement. But yes, you can make new versions of public domain things and protect yours. It just doesn't extend to the original work, just whatever you did to it, which with translations can be complicated to know what you did. So that's probably the hardest thing to talk about. Yeah.
Back to the Lee case.
Yeah.
Was the store owner was cutting up the greeting cards, making coasters. Were they then selling those coasters?
Yes.
Okay. And so that, even though they were selling them, it was not infringement of the copyright.
Money has very little to do with copyright infringement. That's a great question. It's like a lot of my
for personal use, it was for commercial use that they were
Correct.
making these coasters. Okay.
Yes.
Oh, so go ahead.
Oh, yeah, that's a good question. And you're right. It doesn't matter that she was selling it because she had the right to do with the copy of the work that she bought, because she bought the greeting cards. She didn't copy them. So she was able to cut up those greeting cards and glue them and sell them because she wasn't infringing somebody's copyright. She wasn't making a copy. She wasn't distributing copies. So that was allowed. And she didn't make a derivative because she didn't actually do anything creative. She just glued it to something else. If it had been a collage or something, there might be a different outcome. That's a good question.
Can I ask a question too about the Lee case?
Yeah.
So I remember when I was in college, I made a collage out of trash, out of found paper trash on campus. And so I made the collage. I think it was like a Persian carpet was my image. But the collage, some of the pieces of trash were not recognizable. There were wrappers and things, and other pieces of trash were. They had, I guess, logos and stuff on them. Like I remember there was like a green Big Gulp from 7-Eleven container, would my trash collage with some pieces of like recognizable logos on it, would that be infringement?
So that's a really good question.
And I also ended up selling it to someone. So not that I know that you said that the money changing hands doesn't really affect things, but
yeah. So that would be a good law school intellectual property test question because you've got copyright and trademark going on there. Okay. My inclination is that is fine because again, you made a physical product out of things that you owned or, someone else's trash. You didn't copy the trash. Yeah. But the trademark issue is a totally separate one that in that context, I wouldn't be that worried about because when you get into trademark infringement, it's more of a matter of whether or not you're trying to make it look like that product has something to do with you, as opposed to just a trademark case is sort of a similar question. There was a guy that painted a painting of a bunch of motorcycles outside of a motorcycle bar. And on each motorcycle, he'd painted like the Honda logo and the Yamaha logo. And one of the companies sued him. I don't remember. I think it was Harley Davidson, and lost because the court said no one thinks that these motorcycle companies had anything to do with his painting. Nobody thinks he's trying to pass it off as a Harley Davidson product. It's a piece of art that he painted these logos on it. No one thinks that. So that's the same question here. Like, does anyone think McDonald's endorsed your work? Probably not. It's art. It'd be different if you were selling cups that looked like the Big Gulp cups as cups, but that's a different question.
Okay.
So I think you'd probably be fine.
Thank you.
Yeah. All right, going on. So let's see what time it is. Okay, great. So getting a license, if you do want to use somebody's stuff, you do want to make a derivative work or whatever the case is. Like I said, technically you have to have a license in the US. There's no good excuse not to for us. Some other countries have slightly better policies. And I just want to put it on the record that despite being an IP copyright lawyer, I don't always agree with all of these laws. I think some of them go too far. I think that it was written before we had the capacity to make some of the things that we make now. Like in the 70s, we didn't have Photoshop and we didn't have iMovie and all the stuff that we have now that lets us do what we do. And I don't think the law has caught up to the things that we are making that don't feel like piracy to me. This is different. It's different to make a trash collage than it is to rip off someone's whole film and sell it. And we haven't caught up to that. Anyway, side note. So if you don't have a license, it might be fair use. So let's talk about fair use real quick. It's the world's fastest fair use lesson.
Can I ask you a question real quick?
Sure.
Do copyrights apply, US copyrights apply in other countries?
Yes. So the whole reason that we have the Life Plus 70 thing is that we signed a treaty with a bunch of other countries. And we needed, in order to have reciprocity, we had to lengthen our copyright to be as long as they already were in parts of Europe. So yes, there is reciprocity for signatory countries that we're supposed to respect their copyrights and they're supposed to respect ours. And not every country is a signatory, but I want to say there's like at least 70. A lot of countries are. So that is something you can look up. But basically, most of the time, yes. Anyway, fair use. So I'm going to go through these not very interesting factors, and then I'm going to give you an example that makes them make sense. So when you're trying to decide if something is fair use, whether or not you can use it without a license is the point here. There's 4 things to think about, and this is not a checklist. Not all 4 things of these have to be true. It's just a balancing test, as we call it in the legal field. So you would consider these 4 things against each other. So the first one is the purpose and character of your use. What are you doing with this work that you want to use? If it's commercial, it's less likely to be fair use. If it's for education or for nonprofit purpose, it's more likely to be fair use, but not automatically. The nature of the copyrighted work that you're using, and it's sort of the same question here. Are you using a newspaper in a documentary? That is more likely to be fair use than if you're sampling Ariana Grande. That is less likely to be fair use. The amount that you took, and again, this is not a specific number, but it is the question, did you take more than you needed to get your point across? So if you were making a work of art that was a parody, did you put enough of the original elements of the artwork into it that somebody got the joke you were making without literally taking that painting and like putting a new face on it or something? How did you take more than you needed to for someone to get it? And then the most important one is the effect of the use on the market for the original. Will people not buy the original version because they're now buying yours? So I have a couple illustrations of that, but I'll tell you one. There was a lawsuit where a cable channel, I don't remember, one of the old movie channels was making a documentary about horror films. And in order to do this, they wanted to use clips of horror films, obviously. So they might have a segment on like the history of vampire movies from Nosferatu to Twilight. And they were trying to license these clips. And one of the heirs of one of the actors that owned some of his works said no. And the company decided to use it anyway and ended up in court. And the fair use decision went like this. So cable company making a documentary, owner of the footage says no. Purpose and character of the use. That one's sort of a toss-up. It's commercial. It's going to be on cable TV. However, it is a documentary, and maybe half and half there. The nature of the copyrighted work that they took. So that's not in the favor of the cable channel because they're taking an original film. This is not something that's more like a historical photograph or something. It's a film, so not going well. But the amount that they took. So I'm making up numbers, but maybe in the vampire segment, they would show 20 seconds of a film just to say, like, back in Nosferatu's day, they had long fingernails, and now in Twilight, they sparkle. Please compare these clips. So they didn't take more than they needed for that to make sense. And then the effect of the market, the effect on the market for the original. So the point there is people are not going to not now watch Nosferatu or Twilight because they saw this documentary. A 20-second clip in a documentary context does not take the place of the market for that original film. And in fact, somebody probably wants to go see it now because they've seen this clip and now they're excited about it. So that was found to be fair use. So that's sort of the process that you go through. What am I doing with it? What's the original work? Did I take more than I needed? And am I making something new out of it that's different and not going to supersede the use of the original? Some things are always fair use. Quotes or excerpts in a review. So if you want to have a YouTube channel about the progression of crashes in Fast and the Furious movies and you want to show clips of those, you can do that. Parody, you have to be really careful about parody. Parody requires that you are making fun of the thing that you took. You can't just write funny lyrics to a song and call it a parody. It has to somehow reference the work that you took. I think a good example of that, Weird Al always licenses stuff just because he doesn't want to make anybody mad. but he has the alternative polka where he plays these like serious Foo Fighters songs and stuff on the accordion and turns it into a polka. I would say that's a parody because it's sort of poking fun at the seriousness of that genre. Reproduction of part of a work by a teacher or student in a lesson. So if you're teaching a class or taking a class, you can use pieces of works for your presentations or projects. And incidental reproduction. This is a bigger one for filmmakers and photographers, which is if something is in the background and you're not trying to capture that thing, it's fair use. So if you're filming a documentary at a restaurant and there happen to be paintings on the walls, you do not have to clear every painting that just happens to be in the background. That is not to be confused with trademark issues, which sometimes when you see maybe like MTV, The Real World, and all their logos are blurred out on their shirts, that's trademark, and that's a separate question and for a different reason that doesn't really have to do with infringement so much as licensing deals and things like that. So, and another one that's not on here is government works. So government works are mostly fair use. I made a song recently where I used some recordings from a satellite that I got off the NASA channel as my beat, like made it into a beat, which I can do because it's fair use to use government stuff.
Erin,
I was going to say questions.
Yeah, there's a question that maybe ties into this real well. So Allison says, what should a filmmaker do if an actor is wearing a t-shirt with a logo in your film that might go to a festival? I think she means like a film festival.
Yeah.
Sounds like you kind of maybe address that they should probably blur it out because it's a trademark issue.
So you're probably fine. The reason that logos get blurred out on shows is twofold. It often has to do with contracts. Like, for example, if you're making a reality show, often they'll have a contract with Coca-Cola for product placement. So they don't want anyone to have a Pepsi can. So sometimes logos are blurred out because they conflict with the deals that the company has. So that's the biggest reason. And the other reason has to do with morality. Like, for example, if you're filming a bunch of frat boys throwing up the morning after a party and they're all wearing shirts that say Gap on them or whatever, Gap may not be very happy about that. So sometimes you might make that choice just to avoid that situation if the characters in the film are doing something that the companies whose logo it is might not like. But I wouldn't say you automatically have to blur out logos. Those are the main reasons that it happens. And if you're really featuring a company or a logo, at that point, I would just call the company and try to get a sponsorship and get them to give you stuff. That also happens. So everybody's wearing Gap shirts. Cool. Call the Gap and see if they'll give you shirts. So it happens. That's a good question, though. There are other questions? All right. I got a couple more things then, but if anything comes up, let me know. So if you do want to use someone else's work, well, I should say one more thing about fair use. Fair use is a defense, unfortunately. You can proactively decide that you think something is fair use, but that doesn't stop somebody from sending you a takedown notice, sending you a cease and desist letter, suing you. You would then say it's fair use because, but it doesn't get you out of having to go through that process because you can't put up a fair use flag in the beginning and never have to deal with that, unfortunately. But it is good to at least know. And if you're working on really big stuff, like book publishers and filmmakers will usually have what's called errors and omissions insurance, which is essentially copyright insurance, where their team of insurers and lawyers has read through the book, watched the film, and either asked for proof that they have licenses to do all the stuff or said, yeah, we think this is fine. And then they'll insure them against people coming after them. But not all of us can do that. So if you want to use someone else's work, you need to really try to find them. There is no excuse in the US not to get a license. Other countries have what's called an orphan works doctrine, which says that if you do a certain amount of work to find the owner, and that varies by country, and you cannot find them, you can pay a fee to their copyright office. And then if that owner resurfaces 10 years later and says, you never talked to me, then there's money in the coffers for them to get something. We don't have that, unfortunately. So if you cannot get the person to answer you, you're just stuck. And you can decide, then it's just a risk assessment. Do you just want to do it and hope for the best? Because if you couldn't find them, maybe they'll never know. Or are you, concerned about that? Because they could come back and say something. We talked about all that. What if someone is using your work and you don't want them to be using your work? So coming back to my infringement conversation, if you have not registered your copyright and somebody infringes your work, you can sue them for what you can prove you lost or actual damages, which can be very difficult, especially in the digital world, because it's hard to put a value on somebody puts your photo on their blog. What is that worth? It can be hard to know that. It can be worth a lot to you. Maybe that's the photo you were going to, submit to all the competitions and now it's out there. But it can be hard to put a dollar amount on that. If you have registered, you can sue for statutory damages, which there it is, which is $750 to $30,000 per infringement, and then up to $150,000 per infringement if you can prove that it was intentional or that they should have known better, which is why you put that little C in a circle on your stuff, because if that's on there, then you just say, well, that's there, they knew, and that's pretty much you win. So in order to show copyright infringement, the only two things you have to prove are access, that they could have seen or heard your work, and that they are substantially similar. Of course, that can get complicated. But access is a big one. Again, if I made a painting and I never showed it to anyone, I never took a picture, and you happen to make a similar painting, you never had access to mine, so I don't have a claim. But meaning to rip someone off doesn't matter. You can accidentally infringe somebody. I mean, as a songwriter, I have definitely come up with stuff and thought, oh, I'm a genius, this is great. And then a couple of days later, I'm like, oh, wait a minute, that's Duran Duran, or whatever. So it's possible that can happen. If you want to go after somebody for infringement, usually the first step, if it's online, you would send an online takedown. Most big websites that use copyrighted material have a policy for that, like YouTube or BuzzFeed. They have a really easy way to just report it and get stuff taken down. And then if it's your stuff getting taken down, that's where you would turn around and submit a counter notice and say, no, it's fair use and here's why. So that's how that process goes. If it's not online, you would send a cease and desist letter and see what happens. And then as of right now, this is another big change. As of right now, if that doesn't work and you have to go to court, copyright is federal law, so you have to go to federal court. Federal court is more expensive. Federal court lawyers are more expensive because we are not automatically licensed in federal court. I just renewed my license for federal court and I had to take a day-long class that was not free. And then I had to pay a fee and I have to go get sworn in again because I let it lapse. Oops. I don't have any federal court cases right now. And I finally have another one and I'm like, oh no. But the point of the story is it's not the default. We're more expensive. It's more expensive. The filing fee is over $400. So a lot of times just nobody does anything about it unless they think that there's going to be enough money there to make it worthwhile, or if they have enough money to sue you, because it's really expensive to do. So most copyright cases never even get that far. And if they do, they usually settle because nobody wants to pay to keep going to federal court. That's about to change though. And that's a big thing that's gone into, deciding in the past about whether or not you wanted to even, whether or not you felt comfortable putting out something you couldn't get a license for, because that's always just a risk assessment question. But historically, if you're a really small fry, you're not ripping off someone like Disney who sues everyone, you might have gotten away with it just because people, there's no copyright Santa watching you. Like the person who owns it has to do something about it. And they also have to care and they have to know. So if they don't notice or they don't care, or they don't want to do anything about it, then you could get away with it. But now, this is launching in December, supposedly. Supposed to start December 27th. There's going to be a copyright claims board where you do not have to go to federal court. You go through the Copyright Office. And they have put together a team of, I think, 3 people who will analyze copyright infringement cases that are under $30,000. The infringer can opt out, though, and make you sue them in federal court. I'm really interested to see how any of this goes. I just have no idea. I can think of pros and cons. I think on the good side, for smaller creators who previously weren't able to go after infringers because they didn't have thousands and thousands of dollars to go to federal court, now they can do something about it. But on the other hand, those big companies can still just opt out and say, no, come sue me. I think they might not, though, because they don't want to spend their money on that either. And if they think they can settle it in this policy, in this way, with spending a lot less money on legal fees and time, maybe they will. It remains to be seen. Who knows? But I also wonder if this will make people sue each other more in not legitimate ways, just because now it's possible. So I have no prediction about how this is going to go, but you should know it's supposed to start in December. We'll see if it actually happens then. And then the only other thing I wanted to say, we don't need time to talk about trademarks. I just want to touch on Creative Commons and let you know that that exists. I don't know if you guys are familiar with Creative Commons, but especially in the photography world, if you are looking to share your own work and to sort of circumvent copyright, or you want to use someone else's work, Creative Commons lets you both share and use other people's stuff. I don't really have time to get into all of the details, but if you go to their website, it's really straightforward and they have a few short videos. But I have definitely used Creative Commons photographs for projects before, and people can choose different levels of rights, whether that's I just want credit, you can't edit my work, but you can use it, you can't make money from my work, or you can make money, but you can't edit it. There's a whole mix of different options of how you can share things and how you can use things. But it is a way, it's not just for photos, that's just where I find it used the most. Anybody can put their stuff out through Creative Commons. It's not a substitute to copyright, it just narrows the scope and lets people use your stuff if you want them to. Any other questions?
David Shaw is asking, do you need to actively protect or enforce your copyright?
No, and that's a great question, because if you're thinking of trademark, well, you do have to actively protect your copyright, in that no one's going to do it for you unless you have somebody paid to do that for you, but you're not obligated to do so. You don't lose it in the same way that you lose a trademark that becomes generic, like escalator. That used to be a trademark, but now we just call every moving staircase an escalator. So there's no trademark on that word anymore. But it's not the same in copyright. No. Good question. You guys all have good questions. It's fun for me.
This is a good group. Yeah.
Anybody else?
I have a question that I see coming up in the letterpress and printing community a lot. Because we like to work with words, we're often using quotes or parts of things that other people said that are not necessarily older than 1925. And I'm wondering if you can kind of speak to that.
So that's such a gray area, and it really depends, again, on what you're doing with it. I would say, if you are making that quote part of a bigger work where you're maybe juxtaposing this quote against some imagery that says something else or makes a different point, that could be fair use, because fair use is all about commentary. So, like, I don't know, if you took a political quote and put it on some flowers, and you know what I'm saying, like something like that is essentially a parody of some kind, that would be okay. If you are literally just block printing a quote, like the words, and selling a poster of that is potentially a problem. And it also depends where the quote came from, because if it's a quote from a book, then somebody definitely has a copyright on that if it's not public domain. If it's a quote that somebody said on a news broadcast, there may be no copyright in that quote. So it's a complicated one. Although my general answer, if I am not a lawyer for a second, is that if this is something that you are making for yourself to put in your house, not that worried about it. If you're going to go sell prints of someone's quote and it's just the quote on a piece of paper, then, and it's out of a book or something that's not public domain, now potentially that's a thing.
So somebody's spoken word is different. So the difference would be between saying, like, taking part of a speech that somebody made versus using like an Emily Dickens part of an Emily.
Exactly. Yeah, because it has to be fixed in a tangible medium to be copyrighted. So if you took a quote of something that I said out loud at a lecture and made it into a poster, there's not much I can do about that unless I've also written it into a book. Also, I will say that for the most part, people aren't too picky about that sort of thing unless you're really commercializing using their words and it's something that is infringing something they could be doing, you know. Like if you were to take a single song lyric and it's the main lyric of the song and that artist that's something they would put on a t-shirt, they're more likely to have a problem with that than if you pull one line out of a poem or something. So
we've got some questions in the chat that I'm going to kind of read to you.
okay.
So let's see, Victoria's asking, and if I don't get these, or if you guys need to clarify, just feel free to unmute. If you're a student at a university and you complete an artwork for an assignment, who owns the copyright and who owns the artwork itself? When I was at school, the university told me that they owned all the work I created for classes and I was never able to get it back.
That is correct. Most of the time in a student handbook, you can check out your student handbook and see, but usually the university owns the copyright in whatever you did. I am surprised they wouldn't give you the physical work back. That seems weird, but they do typically own the copyright in anything you do at or for school, and not just for school, but at school. So again, I mostly teach in the music department. So when my students go there and are working in the recording studio, sometimes they just make their own stuff in the studio. I'm like, think about that when you're doing that, you know? And I, for the most part, don't think the school is out to get most people. And in fact, one of my students got so mad about that he like got a copy of the handbook and we went and talked to the dean about it. And it was sort of what I thought. They're like, yeah, we do own it, but are we trying to stop you from doing something with it? No, not really, but also we can do something with it. So I think it depends on the school and how they want to enforce it. But yes, the school typically does own things you do at or for school.
And the school has to state that and make that clear to the student ahead of time.
Yeah, but it's usually in the student handbook if you actually read it, because they're usually so long, no one actually ever reads those things, but it's in there somewhere.
What happens with the athletes now with the use of their images and likeness?
Mm-hmm.
The new rulings that have come out, does that have any impact on what you just indicated?
That's a totally different area of law. So that's not really related to copyright. That has to do with the right of publicity. And that's a whole separate thing. And I have not read everything that's come down since that started happening. I do know that they can now monetize that to some degree, which I think is cool. But that's not so much copyright. Right of publicity is a different right that varies by state as far as who can do what with your name and likeness, including yourself and your family and your school.
But if somebody takes a photograph of him, not the school, but somebody in the family takes a photograph of him and he signs it, does the copyright stuff enter in at all at that point?
So if someone in his family takes the photograph, they own the photograph, but whether or not they can monetize that photograph is a different question. And I don't know the answer to that right now because I have not read the latest stuff. But
Can I ask you a question? If you're writing a book and you have an outline or a partial half of a book, can you copyright that?
yes.
Okay.
But again, you can't copyright the idea. So you could copyright your outline and the portions that you've written, but that doesn't really stop somebody from writing a book in a similar format necessarily, because really what you're protecting is your text. So it depends on how expanded your outline is. If the outline is literally like, chapter 1, books, chapter 2, music, you're not gonna be able to enforce that.
Okay, thank you.
Yeah.
Okay, here's a question from Kim. Any problem in making a slideshow of my students' work and putting it on my school website or on my website as an example of my students' work? And it sounds like that maybe got answered because the school owns the artwork.
Yeah, I mean, that's probably fine. I would talk to the school about it because they're the ones you'd have to ask, not the students.
And is it differ if it's a university versus like an elementary school?
I don't know what the policy is for elementary schools, but a university is going to own it. I don't know how that works with like a public ISD. They probably do too.
Another question. What if an actor reads a paragraph from a book in a film, like reading a paragraph of The Bell Jar in a film?
That's another, it depends question. If this is a documentary film and it makes sense in the context of what the film is about, that's going to be fine. If this is not a documentary film and this is a feature film, I think within reason you would be fine. If you're reading whole chapters of the book or something like that, it could be a problem. But no, you don't need to go get permission from Sylvia Plath's estate to like mention the book or to have it there or to read a couple sentences. But I wouldn't just read a whole paragraph without having the rights to that.
And if you wanted to just be on the safe side, you would just let them know. I know I I reached out years ago to the people who own Khalil Gibran's work, asking for permission just to make sure that what I was doing in a very small, limited fashion was okay. And the publisher didn't really care that I was but I did go through the effort of actually asking just to make sure that that would be okay.
And a lot of times that's a good idea, because especially if you're working with bigger publishers or bigger estates, like there's a person on hand to do that. And there are certain estates that don't let anyone do anything. Selena, Jimi Hendrix, those are, Marvin Gaye. But there are a lot of families / publishers, whatever, who are just happy that somebody cares. And as long as you're not going to make $1 million off of it and not pay them for it, they're usually like, cool, give us credit, whatever it is. So it's worth asking.
Yeah. They won't necessarily say no. Emily Dickens might say no, but.
Well, and even if they say no, so this is another interesting fair use point. If it is fair use and you are really convinced that it's fair use, you can still ask. And if they say no, that doesn't stop you from being able to use it if it really is fair use. Just like the documentary thing.
Would you recommend consulting with a lawyer if you're in one of those scenarios where you think, is this fair use or not? And are there lawyers who, like, I guess that's what you do, help consult on those things?
Fair use is so messy. So the only area, so if you're a documentary filmmaker, there is a group that got together and made a booklet of best practices in documentary filmmaking for fair use. Is very clear. And as far as I know, has not been challenged, and there haven't been any problems with any part of it, as long as you're actually abiding by what it says. And you can find that online. I can't remember the name of the entity, but if you just Google best practices of documentary filmmaking, you'll find it. For everyone else, the rules are not so clear, and I do think it's a good idea to ask somebody. And something that lawyers will often do is issue fair use letters, where we'll write an opinion letter, like, yes, I believe this is fair use because, or no, I think this may not be fair use because this, proceed with caution. So that is something you can get someone to do. And also, I just want to put this out there. Maybe you guys already all know about Tala. I used to work there. Tala provides, you have to pay to join, but then they'll match you with a lawyer for free. And then you just pay filing fees or whatever, if it's a copyright or something like that. And they're based in Austin now. It used to be here, but they do still have attorneys who are here. So if you qualify financially, putting that out there, I'll put the link in the chat.
Perfect. And we have one more question, if you don't mind answering one more question, because I know we're over time. The U.S. Registrar Office, the only place or even best place to register a copyright for a full written story? Are there other places like the Screenwriters Guild? Is the Screenwriters Guild an option?
That is not a substitute. So copyright is a copyright, and registering it with the Screenwriters Guild gives you certain benefits that you're going to get through the Writers Guild, as far as enforcement and pricing and whatnot, but it does not substitute for filing your copyright. So two different things. It's just like if you're in music, you register your song with ASCAP or BMI to get paid for public use of your song, but that's not a substitute for the copyright. So do both. Anything else?
I have one more question.
Yeah, go ahead.
I recently saw somebody they created the likeness of a well-recognizable character and put it on a greeting card to sell it. And it's a highly recognizable fictional character. And I really questioned whether that was, and it was very current as well, and whether this person could have gotten a cease and desist just for recreating a character. It wasn't a human being. It was a character that clearly somebody else had created.
I will answer that by saying one of my good friends' entire jobs is to go to anime conventions and serve cease and desist on everybody who makes anything with characters that aren't the company.
Okay.
So yes, that can be a problem. And it depends on the owner and whether or not they care. But if it is a Disney character, absolutely do not do that. They've sued daycares for painting Mickey Mouse on the wall. They are a worst. Some other companies may not be quite as litigious, but not a good plan, probably. Unless it's a parody and you can justify it as part of some statement or something, but I'd still be afraid.
Okay, thanks for confirming my gut on that. I was like, okay.
Yeah, probably not. I'm not going to tell on anybody, but I wouldn't do that.
Yeah. Okay, we have one more question. Can the college claim copyright to the photos and materials I produce for classroom use?
So from the teacher's perspective, that's an employee handbook question, and the answer is probably yes.
Yeah, I think the answer, I would, given other businesses that I've worked at, they often claim ownership of your work.
Yeah,
Do
probably.
the
probably so.
students register the copyright before the project is completed at the school?
Wouldn't matter because it's essentially the same as a work for hire. So the school owns it before you even do it. You can't circumvent them. But you can talk to the school. I mean, I don't think most schools, I mean, your example was an exception, but I don't think most schools are trying to keep students from doing things with their work. I think that most of the time there's a way to work something out if you talk to them about what you're trying to do. But yeah, they do own it, and there isn't really a way to not have that happen. Do your best work at home, yes.
Oh, so if you're in college and you're doing your work at home, not on the campus, then
I
you
mean,
get
if it's not for class, if it's
If
for
not-
class, you're turning it in, or you did it with school equipment, or you did it at school time or during school hours, that's going to be a problem. If you did something at home and never took it to school or whatever, then no. And the student handbook should give more clarity on that and what the parameters are. So
That's so interesting.
students are always surprised to learn that. So
Yeah. And it looks like, how formal does the school have to be? What about a workshop at a local art center like us? I don't think we claim ownership to anybody's work if you create it here with us at the printing museum while we're teaching. That is your work of art.
it has more to do with the agreement. So the reason that the schools own it is not by nature of being a school, but because the student handbook says that they do.
Yeah.
So if the printing museum doesn't have a form that says we own everything you make in this class, then you do not. So. Well, thank you for having me. This has been fun.
Yes, thank you so much.
Erin, this was great. Thank you.
Yeah, such a great presentation, very detailed, answered a lot of questions. I hope everyone got something out of it.